Welcome, everyone. We're so glad you're here today for this important conversation. My name is Ala Holmes, Program Manager for the Witness for Justice Initiative at Acacia. It's an honor to welcome you to this special Q&A webinar with two former immigration judges who bring deep insight into the inner workings of our immigration court system. As you join the webinar, we invite you to introduce yourselves in the chat, share your name, where you're joining from, and what drew you to this conversation about transparency in immigration courts. Before we begin, just a few quick housekeeping notes. This session is being recorded, so others in our network who couldn't join live can still benefit from the discussion. Please note that this webinar is off the record to members of the press. If you have questions related to press engagement, please contact our communications team directly at press@acaciajustice.org, which our team can put in the chat as well. The Q&A function is open throughout the session, so feel free to drop in questions or reflections as we go. We will address questions, including those that many of you submitted during the Q&A portion at the end of the webinar. So let's start grounding ourselves in why we're here today. Every day, immigration courts make decisions that carry life-altering consequences: detention, deportation, family separation, and return to dangerous conditions. These are civil proceedings, but the stakes couldn't be higher. And yet, these decisions unfold in spaces that are largely invisible to the public. As Judge Dana Lee Marks once said, immigration proceedings are death penalty cases tried in traffic court setting. That stark comparison reminds us of the gravity of these hearings and the lack of transparency and safeguards that surround them. You've likely been hearing in the news and the recent This American Life episode, which was circulated earlier this week, about the serious threats to due process unfolding in our nation's immigration courts. These are not isolated incidents. They reflect a broader pattern of systemic erosion that undermines the integrity of the court system and the rights of those who appear before it. We will be touching on several of these developments and concerns in our discussion today. Since early 2025, the Department of Justice has fired over 100 judges without explanation, many of whom were known for upholding due process in their courtrooms, and downsized the Board of Immigration Appeals by nearly half, reducing the capacity for meaningful appellate review and increasing the risk of wrongful deportations. A new rule now allows temporary immigration judges to be appointed with minimal training, some serving for just 6 months. These appointees may lack the immigration law expertise needed to make life or death decisions. ICE attorneys are now asking judges to dismiss cases outright, often leading to immediate detention and deportation without a full hearing. New case completion quotas pressure judges to rush decisions, deny continuances, and issue more in absentia orders for not appearing in court, thus deporting people who may not have had a fair chance to appear or prepare. These changes don't just affect legal outcomes, they ripple outward, impacting families and communities. They're not just technical or procedural shifts. They represent a real departure from the basic principles that we expect from any court system: fairness, transparency, and judicial independence. Acacia's Witness for Justice Court Observation Project is a people-powered response to this crisis. This national initiative brings visibility to immigration courts through coordinated observation efforts. Volunteers receive training and support to attend hearings, document what unfolds, and share their reflections with the broader public. At its core, this work is about accountability and elevating the stories that too often go unheard. The goals of the project are to document what's happening in immigration courts, to expose due process violations and systemic failures, to raise public awareness about a system that often operates in the shadows, and to empower volunteers to share what they see. We're collaborating with existing court observation projects across the country. If you're already involved with a local court observation project, we encourage you to stay engaged and to also join Witness for Justice events to learn how to elevate your observations. While immigration law often makes headlines, the everyday realities inside these courtrooms remain largely unseen. Witness for Justice seeks to change that. We're building a movement, one that amplifies voices, brings transparency to hidden spaces, and builds momentum for long-term reform, including the push for independent Article I immigration courts. At the heart of this movement is presence. In immigration courtrooms where families face life-changing decisions, being present is a powerful act. Witnessing isn't about intervening. It's about choosing to show up, to affirm dignity, and to say, you're not invisible, your story matters. Thank you for being here. Your presence helps shine the light on injustice and affirms the humanity of immigrant families. Whether you're here to advocate, learn, or support, your witness and your voice truly matter. Today, we're honored to be joined by two former immigration judges, Ilyce Shugall and Chloe Dillon. Both bring extensive experience from the bench and a deep understanding of the systemic challenges facing our immigration courts. Ilyce has been practicing immigration law for over 26 years, primarily as a nonprofit attorney. She was an immigration judge for 18 months during the first Trump administration and resigned in protest over the administration's policies. She is currently a managing attorney at Immigrant Legal Defense, a nonprofit immigration legal services organization in Oakland, California. Chloe Dillon is the head of criminal immigration defense at the Private Defender Program, where she guides attorneys through the complex intersection of criminal and immigration law to help minimize immigration consequences for clients. She brings deep expertise from her decade as a federal public defender and a trial attorney on the bench at the San Francisco Immigration Court. Chloe served as an immigration judge until August 2025, when she was fired without cause by the Trump administration. She now leads trainings and community outreach across San Mateo County to support immigrant communities. Our two panelists will offer rare insight into what's happening inside these courtrooms and what it means for justice. From procedural shifts to political pressures, they'll help us understand what's changed, what's at stake, and why public observation plays a critical role in protecting due process and accountability. Thank you both for being here. To start, we'll hear a bit about their journeys to the bench and how those experiences shape their perspectives today. So we'll go ahead and jump in. Could you share a little bit about what drew you to serve as immigration judges and how that perspective shapes the way you view immigration courts today? Can we go to Ilyce first?
Hi, thank you. Sure. So at the time that I became an immigration judge, I had been practicing immigration law as an advocate for about 18 years. So I had extensive immigration law experience and saw that so many judges on the bench did that, and thought that I could really help diversify the bench. I applied during the Obama administration, during a time when more attorneys from the advocate side of immigration law were being appointed after almost no one from the advocate side had been appointed during Bush's 2 terms. So I thought it was really important to um, join the bench and bring my experience and expertise and perspective to that world.
Hi. Thank you all so much for joining this webinar and for your activism and wanting to know more about this process and know more about the immigration courts. I think I can speak on behalf of immigration judges, both former and present, that we want you to care about this. And so thank you for caring. I, as Alla said, was a federal public defender for 10 years in San Diego. And so a lot of what I was doing in San Diego was border work that dealt with immigration. And so I was practicing criminal defense. But outside of that, a lot of my legal career has been immigration oriented. I did pretty intensive immigration work in law school. I went to law school at University of Arizona in Tucson. I saw at least one person here from Tucson, which has a very strong immigration clinical program and courses. And so I came out of law school feeling really educated in immigration law, which is not on the bar exam, if any of you are curious, but immigration law is not on the bar exam in any state, and it's not something that otherwise lawyers are necessarily trained in. It's considered this very specialized area of law that you essentially have to take it upon yourself to learn immigration law. And then I clerked for the immigration judges at the Los Angeles Immigration Court for 2 years before I became a federal public defender. And then my work as a federal public defender actually included looking at prior removal proceedings in immigration court in order to challenge criminal charges of illegal reentry. And so I joined the bench in large part because I felt that while there are always things to learn, and I'm a person who always wants to hear what other people have to say, and that was my attitude on the bench, is I really wanted to hear everything from both sides. I did feel that, like Ilyce, I had a good understanding of immigration law and a very relevant background, and that I felt that I would decide cases correctly and fairly, and that I would bring my legal knowledge and experience, as well as my experience working with individual people and knowing how to talk to individual people from the bench. And so I just felt that I would do a good job. So that's actually that's the principal reason why I applied to be an immigration judge, is I felt that I would be good at the job.
Thank you both so much. Ilyce, you've spoken about resigning because you could not in good conscience carry out the administration's policies under the first Trump administration. Can you share what went into that decision and what you want the public to understand about why it mattered?
Sure. So to put things in perspective, at the time I resigned, it wasn't anywhere near as bad as it is now. So things have gotten significantly worse. But at the time when I resigned, the first Trump administration had recently rolled out MPP, the Migrant Protections Protocol policy, which was the Remain in Mexico policy, and was sending immigration judges to courts on the border to hear those cases. Immigration judges had no choice in the matter as to whether or not they would be sent to hear those cases. I knew that I would not hear those cases. Those cases were a joke. There was no due process in those cases. Individuals were unable to appear for hearings because they had been kidnapped while in Mexico, were in horrible conditions, and judges were having to order them removed in absentia. And that was just something I knew I could not participate in. Also, matter of AB had recently come down from the Attorney General, which was the first Attorney General decision during Trump 1.0 that essentially held that victims of domestic violence should not be eligible for asylum. I continued to grant those cases despite matter of AB, because there are still ways for individuals to qualify for asylum despite that decision and decisions that have come out since. But that was another factor. And then the other issue was that for the first time ever, EOIR, which is the Executive Office for Immigration Review, the agency that oversees the Immigration Courts and Board of Immigration Appeals, started imposing quotas on how many cases immigration judges needed to decide, how many motions needed to be adjudicated within a certain period of time, and really started putting pressure on the judges to hear cases very, very quickly in a way that was totally unrealistic and interfered with individuals' due process rights. And then the last thing that was happening around that time was the beginning of the family separation policy. And while that wasn't directly attributable to the courts, it was a Department of Justice policy. And for those who don't know, hopefully all of you attending this know by now, but immigration courts are non-independent courts. They are part of the Department of Justice. And I was appointed under Attorney General Sessions, who made it abundantly clear to the immigration judge corps that we were attorneys, not judges, and we were attorneys serving at the will of the Attorney General. So his policy to separate families at the border, while not directly impacting the court, was part of the Justice Department, and I did not feel like I wanted to continue serving within the Justice Department.
Yeah, that sounds awful and unworkable as a judge. Thank you for sharing those insights. As I mentioned earlier, immigration courts can often feel like a hidden world. Chloe, from your vantage point on the bench, what surprised you the most about how the system works day to day?
I mean, I think that I thought when I transitioned from being a lawyer to being a judge that it was a big transition, and I felt like I was acclimating to this idea that I was the decision maker, that I would have independence, that I had to exercise that carefully and exercise my judgment carefully, but that ultimately uh, my decision was my decision. I was not prepared, I think, for the types of political pressures that I felt came with the job. Uh, I felt that there was discussion, but particularly since this administration came into office, that there was a lot more discussion about uh, specifically about whether the Department of Homeland Security was satisfied with the way that we were doing our jobs, and whether we were doing our jobs in a way that afforded the Department of Homeland Security's position really, I think, a position of primacy. And I don't think that that was just internal discussions. If you read the memos that are being issued by the immigration court, it's abundantly clear that the principal concern is whether the Department of Homeland Security is getting what it needs. And uh, so I think that that can be really toxic to the position of a judicial officer. That I think when you think about a judge, you're right when you think about a judge as having independence and supposed to exercise this independence and be outside of those political pressures and those political concerns. But unfortunately, as Ilyce said, because the immigration courts are under the Attorney General, and so currently the immigration courts are, I guess you could say, managed by or under the authority of Pam Bondi, um, that there isn't that independence, and that can really infect the decision making, right? Because it's not simply that you're being told specifically what to do; it's that you are existing in an aura in which you are given the impression that you are not doing your job correctly. And indeed, they are firing immigration judges, as you have heard, and explicitly using in that form of intimidation of, if you don't do your job correctly, you will be fired, um, to put pressure on how you make decisions. And that is absolutely not what we want in judges. I think. I don't think that that's what anyone wants in a judge, but that is, I think, what's happening.
Absolutely. Thank you both for sharing that. I mean, we'll get into judicial independence and the specific directives that you all may have received a little later, but that's very disturbing to hear. The Witness for Justice program calls for bringing transparency to immigration courts. From your experience, Ilyce, why is transparency so critical, especially at this moment?
Well, the general public has very little information about the immigration court system. I think the one upshot of what's happening right now is that there has been more coverage about the immigration court system. And so the public is at least starting to get a taste of what happens in immigration court. But I do think it's still like a very unknown world to most people in this country. And so I think having more transparency and having observers who can report out to the world about what's happening and the injustices that they're seeing is really important and really crucial, in the hopes that eventually it can make for positive change.
Thank you. And Chloe, what role can court observers play in shining a light on what otherwise happens behind these closed doors?
So I want to say that I've had court observers in my courtroom when I was on the bench. And so I'm really familiar with what you all are doing. And so I can tell you that I do think that it matters. First of all, you're there asserting that this is a public arena in which you have, and generally speaking, under the law, there's a First Amendment right to have access to courts. That's a public right to be able to go into your courthouses and know what is going on and have a transparent judicial system. And while that is a little bit more complicated in an administrative context like this, I still think that you should think about that you are exercising a constitutional right when you go into a courtroom, and you are helping support our democratic system, in my view. I think that you have a right to be there. But on the level of the immigrants who are there, I think that you are critical to cataloging what happens there in the courtroom. You're not a bystander, you're a witness in many ways when you're there as a court observer. And if you were not there, those things that happen might not be cataloged. And so, as a witness, you are bringing that transparency and making that record of what happens in the courtroom. And it's critical, I think, uh, to an understanding of this landscape that is changing day to day and that is really radical and different than how it has been for decades. This is a moment, I think I can comfortably say, also having worked in the arena of the immigration courts for basically almost 2 decades now, and Ilyce is even longer, that this is truly a unique moment and the things that are happening have not happened before. And you are an important process of cataloging this moment. So thank you for doing that. And I do think that what you're doing matters, and it can even, I think, help hold uh, the people who are working for the government, which used to include me, accountable for what they're doing on a day-to-day basis, making sure that they are doing the things that they are supposed to be doing.
Thank you for that. And if someone on this call has never set foot in immigration court, what can they expect to see and what should they be watching for?
So, immigration court looks like a normal courtroom. Small, but most of them are small. But it does look like a normal courtroom. Uh, I think one thing that stands out to many people who are new to the immigration court system is that the government is always represented. There's always an attorney appearing on behalf of ICE. While on the non-citizen side, non-citizens are referred to as respondents in immigration proceedings. On the respondent side, often there is no attorney. So you often have someone who is unfamiliar with the system, new to the United States, doesn't speak English, sometimes not well educated, appearing by themselves up against a trained attorney for ICE. And so I think it's important to really think about that when observing the whole context. The other thing that should happen, since you all are observing master calendar hearings, is at initial master calendar hearings, immigration judges should be explaining rights to the non-citizens. They should be getting an explanation of all their rights in the proceedings in a language that they understand. And I think Chloe can speak more to this under the current administration. But even during the first Trump administration, those rights advisals were definitely blown through by many immigration judges. So it's really important to be observing that and making sure people, particularly people who don't have an attorney, are getting that explanation in a language they understand. The other thing that I think is important to understand, and this is particularly true in the San Francisco and Concord immigration courts, is we see a lot of non-Spanish, non-English speakers from both Guatemala and Mexico. They speak indigenous languages, and oftentimes, to save time, the system tries to push them into just doing their case in Spanish, which is not their best language. And that often is pretty apparent pretty quickly. But again, because of the extensive pressures on the immigration judges right now, sometimes they just continue in Spanish because it can be really challenging to find an appropriate interpreter. So those are some of the things that I think are good to be on the lookout for.
That's a good example, Ilyce. In our local area in the Bay Area, the indigenous languages from both Mexico and Central America are a good example, but I think you will also see language issues happening with Africans. So you'll see that their first language is something that is not English or French, but they understand enough English, French, some other type of European language, that they're going forward in that language rather than potentially their native language, the language that they speak and understand best. The question that I asked as an immigration judge, probably at least two, what's the language that you speak and understand best? Not, do you understand me? Seems like you understand me. Let's go forward. What's the language that you speak and understand best? Um, and so that's, and then you can see it from East Asia as well, Chinese dialects, the different Chinese languages. So, that's, I think, something to keep an eye out for, is whether people are getting interpretation in the language that they speak and understand best.
Yeah, thank you both for flagging those examples of how having observers in the room really ups accountability for the judges to avoid cutting corners on things like language access and providing advisals, etc. So let's move on to talk about some of the policy shifts and procedural trends that we're seeing in the courts. Our court observers have already reported seeing new policies and directives being implemented in real time in the courtrooms, including pre-termination of asylum claims or respondents opting for voluntary departure rather than seeing their cases through. Could you provide an overview of some of the key procedural changes or trends that observers should be aware of at master calendar hearings or status hearings, and how these shifts impact case outcomes? And Chloe, I'll turn to you first.
So you'd like me to, sorry, I got a little bit off track there. You'd like me to cover like how pre-termination changes case outcomes and things like that?
I think that Ilyce is going to talk about pre-termination. Maybe you could talk a bit about some of the lower attendance that we're seeing in courts due to court arrests and some of those more recent changes.
Sure. Okay. So you are going to see lower attendance at master calendar hearings because we have seen a drop in attendance due to fear of getting arrested at the courthouse. And so then you will also see at the end of the calendar, usually, but sometimes right in the middle of the calendar, judges doing in absentia orders. There is a procedure for doing an in absentia order. You do have to look at the evidence, find that the Department of Homeland Security has submitted sufficient evidence in the case to warrant an in absentia. You also have to make a finding as to notice that the person received clear, unequivocal, and convincingly that they received proper notice of the hearing. And so those types of findings are the findings that you make before you enter in an in absentia order. So you can observe judges when they make the in absentia orders. But you will see some lower attendance as a result of that.
Thank
And
you.
then I think Ilyce was going to cover some of the other aspects of the differences in the way that cases are being handled.
Yes, thank you.
Yeah, so some of the other new things that we're seeing are motions to dismiss by the Department of Homeland Security in order to move forward with expedited removal. That process, when that process started, that's when we really started to see ICE officers in the courtroom or just outside of the courtroom. And while in many cases, immigration judges are not dismissing cases on the spot, some still are, but some are not. Some are providing the non-citizen and their counsel, if they have counsel, time to respond, because when one party files a motion, the other party should have 10 days to respond. And so some judges are following that. Nevertheless, ICE officers are still waiting for individuals for whom DHS moved to dismiss, and then they're taking them into custody. And I also just want to say, sort of as an aside, detention has always been a tool that has been used by ICE, formerly INS, to convince people to give up their rights and give up pursuing their cases. And so the use of detention, particularly in this context, is really a way for ICE to push people to not try and fight and to just accept their expedited removal, not pursue their fear-based claims, and so that the government can continue with its agenda of deporting people as quickly as possible.
Just quickly responding to two of the questions in the chat. I think that what I was trying to get at is whether the question is asked that the person, what is the language that you speak and understand best? One of the questions was, well, how do we know if that's their best language if the question is never asked? And I think exactly, does the question get asked? Is this the language that you speak and understand best? Yeah, not possible to know whether somebody's fluent, because you don't speak the language. Lower attendance, definitely in person. And then, WebEx is kind of still new. It was something that really came into effect during the pandemic. It wasn't a long-term way of handling the majority of cases in immigration court. People have been appearing by video for some time from detention facilities, not just at the beginning of the pandemic, but in large part, immigration court proceedings were still in-person proceedings until the pandemic. You may see lower attendance on WebEx. You may see judges not allow people to appear by WebEx, all of those kinds of things. And so, you can make note of that. Like, what are you seeing? Are people able to appear by WebEx or not able to appear by WebEx? Those are all part of your witnessing what's going on.
Yeah, thank you. And Ilyce, could you speak a little bit to asylum pre-termination and what it means and what folks might be seeing at the master calendar stage related to that?
Sure. So this is a very complicated and technical area of law. So I'll talk about it at sort of a broader, higher level. There's basically three different bases on which DHS is currently moving to pre-termit asylum applications. And pre-termit means dismiss them, means that the immigration judge, DHS is asking immigration judges to deny the application before actually hearing the case. So asking that the judge just summarily deny the application based on what is currently before the judge without having a hearing on the merits of the application, which is very much a new thing. And so the two primary bases are if the application is not fully completed, DHS can move to dismiss based on a BIA precedent decision, fairly new decision. And also if the application and supporting evidence do not make a prima facie showing of eligibility for relief. So if the application in conjunction with documents submitted with the application do not suggest that there's actually a winnable claim, DHS can move to pre-termit the application. And this is happening at both master calendars and individual hearings. So for those who are observing, you might see DHS say, well, we have an application in the file, but it's not fully filled out, or it doesn't reflect that the person actually has a prima facie claim for relief, and therefore we're moving to pre-termit. And judges are granting those at the master calendar stage. And if there's no other form of relief, that means that the person is ordered removed on the spot. The third and sort of even more complicated ground for pre-termination is under the third country agreements. So the US government has signed agreements with other countries to essentially take asylum seekers. And so we heard like 2-ish months ago that DHS was starting to move to dismiss many Latin American claims, so South America, Caribbean claims, to force those individuals to apply for asylum in certain Central American countries. There seemed to be a big push for that for a bit, and then it seemed to slow down. So I mean, those of you who are actually observing might have even more information than I do as a practitioner because you're in a bunch of courts on a more regular basis. But from what we're hearing, DHS is not dismissing that many, or not moving to dismiss or pre-terminate that many cases based on these asylum cooperative agreements. But it is something that they have done, and we expect they'll continue to do.
Thank you. And I think you both may have touched on this briefly, but how has this affected or increased the number of respondents who are now accepting voluntary departure or choosing to take voluntary departure because some other forms of relief may be closed off to them or not available?
Yeah, I think that you will see that people are asking for voluntary departure because they want to leave on their own terms and they think that deportation is basically inevitable. And so, certainly all of these policies put together and the impression that I think respondents are being given in immigration court is that deportation is inevitable. And so I should just try to do it in a way that is the least terrible for me. So, yeah, I think that you will see that. And I do think that, just want to reiterate that, in a memo not that long ago, what the immigration courts told all of the immigration judges is that we expect you to complete 900 cases a year, or you have fallen below performance goals. As you will see, when someone's application is pre-terminated and they are ordered removed on the spot at a master calendar hearing, that's a completion that goes right in their finished case category. And then you probably won't see, because asylum hearings are private hearings, but an asylum hearing is at least 3 hours of testimony. They can sometimes tick over into 2 hearings. To actually hear and complete an asylum case takes a lot of time and a lot of effort. And so there is this, when you put those types of mandatory performance goals of completing a certain number of cases, it is absolutely incentivizing removal orders. It's incentivizing the quickest way to complete the case. And the quickest way to complete the case, there isn't a quick way to complete the case that is favorable to the immigrant. If you are going to complete the case in a way that's favorable to the immigrant, you're going to need to hear all the evidence and make a decision on their application. If you are going to complete the case in a quick way, really, the way to complete a case in a quick way is a removal order. And so that's the problem with these types of performance metrics that are being handed down is that they have absolutely glaring incentives written into them that favor removal orders over hearing applications and deciding them favorably for immigrants. So I was going to talk really briefly, I think, about court observer well-being and about how this can be a difficult process to appear in immigration court. And I just want to touch on that briefly so that we can move on to some of the other uh, aspects of the conversation. Immigration court is an emotional place. I went through tissue boxes like on a weekly basis. And so don't feel like, if you are feeling emotional about what you are experiencing and observing, that this is something that that is somehow inappropriate, or something that isn't, that you're not doing it the right way. It is something that is emotional even before all of this was happening. And so what I would say is that make sure that you take the time to process your emotions and that you are taking care of yourself. And if you feel nervous about going into court, you're not alone. The people who are there also feel nervous. I felt nervous the first time I went into a courtroom as a lawyer as well. So just remember that this is a public place, that what we strive in a democracy for is a public system of justice that is held accountable. This is your government, and it's never been more critical for you to exercise those rights. That this is your government, and this is a public institution, and it belongs to everyone.
Thank you so much, Chloe, for flagging the well-being aspect of being a court observer, which can be a really emotional process. And I do want to note that as part of the Witness for Justice project, we are offering decompression sessions for our volunteers and our observers, where you have a chance to share your impressions and take that time to process what you're seeing in the courts, because it can be very difficult. I want to just take a step back for a moment. You both spoke about the larger trends and policies that are being reflected in the courts. Do you have anything else you'd like to add about what the public should understand about the implications of these new policies on due process? And Chloe, I know you already touched a bit on how forms of relief are being closed off, and folks are choosing voluntary departure even in situations where that might not at all be the best option for their case, but they're being made to feel like that's their only option.
Yeah. Yes, all of this has implications for due process. People should be able to have a fair and full decision on the applications that they have filed. That is what due process is that it's hearing the evidence and making a decision. The legal definition of due process is notice and an opportunity to be heard. So when you are watching what's happening in immigration courts, thinking about whether this person has had notice and been able to prepare for what's happening and whether they are having a full and fair opportunity to be heard, that's the heart of due process.
And I would just add that, I mean, all of you who are here because you actually care about these issues, right? So you probably have a better understanding of the immigration system and immigration court system than the general public. But I think it's also really important to recognize that, we've heard for decades politicians and other anti-immigrant advocates say people should just get in line, people should do things the right way. And I think it's important to really think about what our immigration system looks like and what it has looked like for decades. There is no line for most people. Most people don't have a way to immigrate legally other than through seeking protection-based forms of relief. And if people are in the immigration court system, they are doing it the right way. They are seeking protection the right way. We are seeing many people who entered the country through CBP-1, which was a form of which was an application process created during the Biden administration to allow people to enter in a safe manner. There were many problems with CBP-1, but it was a very, very much a legal way for people to come to the country to seek protection. And, those individuals are being detained. There is an injunction in place. They can't be put into expedited removal at the moment, but those individuals are still being attacked by this administration. So I think it's important to think about the context and understand the context of all of the rhetoric around our immigration system and immigrants when you're observing these proceedings.
Thank you so much. And I think you already proactively addressed my next question, which is, what is one misconception about immigration courts that you wish more of the public understood? I mean, do either of you have anything to add to that besides the processes that Ilyce already identified?
One thing I would add is just the right to counsel. Because I think, again, like this group probably understands this by now as you've been observing, but I think the general public thinks that immigration court, like the criminal court system, has a right to appointed counsel. And that's just not the case in immigration court. There's a right to counsel at no cost to the government, which means that individuals in immigration court proceedings, except for like a very small exception for individuals who are found mentally incompetent to represent themselves and are detained, which is a very small universe of individuals in immigration court proceedings, everyone else does not have the right to appointed counsel. The government does not pay for counsel, and individuals have to navigate finding either a nonprofit organization to represent them for free, which is really challenging because there aren't enough of us, or they have to find resources to pay for private counsel, which has become more and more expensive because cases have become more and more challenging and complicated and take so much time and effort.
Yes. just echoing what Ilyce said, it's just this very, very small percentage of people who are mentally incompetent to be able to be in court by themselves that get appointed counsel. Everyone else, which includes children, no matter how young they are, do not get an appointed lawyer. So children are going through this process without counsel. And there has been arguments for that that have been raised prior, even, going back a long time at this point. But it's still the case that even children don't have appointed counsel, and children are essentially reliant on the types of organizations like Acacia, who organized this panel today for representation.
Thank you both. And sort of circling back to some of the broader issues that you've already touched on, for those watching that have not been involved with court observation before, do you have any additional thoughts on why they should get involved right now?
I think I said my piece about why I think you should get involved. Ilyce, do you have anything to add?
I just echo what Chloe said.
Well, thank you both so much for sharing these insights and experiences. I know you've helped this group better understand the realities inside immigration courtrooms and the urgent need for transparency, accountability, and public engagement. Now I'd like to turn to some of the most asked or commonly asked questions that were submitted by registrants ahead of time. Since we're nearing the very end of our time together, we'll only be able to touch on a couple of the most commonly asked questions. If we aren't able to get to your question today, we hope that you'll consider registering as a volunteer with Witness for Justice, as we'll continue offering trainings and engagement opportunities around recent policy developments and changes unfolding in immigration courts. So first, I'll turn to Chloe. How do we ensure judicial independence despite the courts being under the DOJ? And if it's not possible, how do we push for reform?
So many of the judges who were terminated without cause, which includes myself, have fought their termination because, as you may be aware, federal employees have added employment protections. Generally speaking, I mean, employment protections are different in every context in every state. Within the federal government, generally, once you passed a probationary period, you could not be fired at will. There had to be cause for you to be fired. But this administration has taken a different view that federal employees are essentially at will employees, and in particular, quasi-judicial officers or immigration judges are at-will employees who can be fired at will. And that was really the only thing that we were told when we were terminated is that we could be terminated at will. And so I think that what you will see, and this may be of interest to you, is that legal argument is going to play out over the next 6 months or so. I think you will see a Supreme Court decision on whether quasi-judicial officers, and when you think about that, immigration judges can be fired at will. So I do think that is critical to an understanding of how we have independence on the bench, because if you can essentially replace the bench every 3 to 4 years or whenever the party in power changes, then how do you ensure judicial independence and that people are making decisions just based on the law and the facts in front of them and not based on political motivations? And you, I think, will also have a hard time recruiting judges who want to stay because they will feel like, well, there's no job security. And so, yeah, that the Supreme Court case that I think there's been a lot of news that it is likely to be overruled is called Humphrey's Executor, and you can keep an eye out for how that evolves. Absent those kinds of protections, like for-cause protections, there's been a movement by immigration judges for a very long time. For decades at this point, for immigration judges to have a different position within the government, to be Article 1 judges, Article 1 of the Constitution, as opposed to being under Article 2, which is the executive branch, the president and the and the Attorney General. And so with that, then judges would not be able to be hired and fired at will by the president, and it would help ensure their judicial independence. So certainly, I think in my view, supporting judges becoming Article 1 judges as opposed to being under the president and the Attorney General is a way to ensure that judges are independent and are making decisions based on the law and the facts of the case and not based on politics.
Thank you so much, Chloe. And a question for Ilyce, which was asked in different ways by multiple folks who registered for this webinar. What do you think the immediate future of EYR looks like under this administration? And what about in the long term?
I think what we are seeing is the administration's efforts to just destroy the immigration court system as it exists today. And not just the immigration courts, but also the Board of Immigration Appeals. The precedent decisions that we're seeing from the Board of Immigration Appeals have all been adverse to the non-citizen since the beginning of the administration. Every single one of them, and there's a lot of them. Published decisions were coming out constantly before the shutdown. They've slowed since the government shut down. And they are also written in a way that is clearly influenced by the political climate. And then, as we've discussed throughout this presentation, we're seeing many judges be fired. Judges who were still on probation just being terminated, judges who are off of probation like Chloe being fired. And we are seeing the government weaponize the immigration court system against non-citizens. So I think in the immediate future, and for at least as long as this administration is in power, I think we're going to continue to see the erosion of the immigration court and Board of Immigration Appeals system. And I mean, it's October. We are 9 months into this administration. So I think it's important to think about that and have that perspective because they're only getting started. We know that JAG attorneys are going to be joining the bench with little to no training. That is going to also change what the immigration court system looks like, significantly change it. And while I will say, I had some immigration judge colleagues, Chloe had immigration judge colleagues that had a JAG background, this is different. This is taking military attorneys out of their current role as military attorneys and plopping them into the immigration court without appropriate training or any immigration law background. So I think we will see like a militarization of the court system. I think that's the immediate future and the, not so immediate future. I do hope that what is happening during this administration will finally convince Congress to act on making the immigration court system independent. We had hoped after the first Trump administration that there would be more momentum for an Article 1 court. And there was a lot of advocacy for it, and a bill was introduced in Congress during the Biden administration, and it went nowhere. And while there's been advocacy for decades, as Chloe mentioned, for an independent immigration court system, there just has not been the political will. And so my hope would be that after this administration, which has made a very clear effort to destroy the system, that there will be political will to make it independent in the future.
Yeah, I mean, I can just say, even if I were offered the job of an immigration job or of an immigration judge again, to be honest, I'm not sure that I would go back because of the political pressures in particular. And that includes the fact that there would be no job security for me. And so I just, echo what Ilyce was saying, that you're seeing the dismantling of a system that has existed for a very long time at this point, probably like 50 years at least that the immigration courts have been around, more than that, 60 maybe, something like that.
UIR was created in the early 80s.
Yeah, yeah. So so this is a momentous moment where you're seeing really a democratic structure and institution, I think, really being dismantled. About the militarization, to be clear, the military lawyers don't have to have any level of experience. It could literally be a first year lawyer, somebody recently barred, who all of a sudden has just become an immigration judge in an area of law that they've never studied and that they don't know. The second thing is that some really, I think, people who've looked into this and who understand both the interaction of military law and the EUIR policies and the role of an immigration judge have raised the issue of that uh, the military lawyers would still be in like they're not leaving the military. The people who have become immigration judges who are former JAG are former military. They are not in an active duty role in the military. And I have never been in an active duty role, but people who have any understanding of military law, of what it means to be an active service member, and the way in which your primary duty is to follow orders, just thinking about the complicated aspect of that when you have somebody who is an active serving member of the military who has military code and law that they have to follow concurrent with this idea that they are supposed to be. I mean, it's not. How do you can't both be somebody who's following orders from the executive branch and who is an independent decision maker and who's a neutral decision maker. Those two things are squarely at odds. And thinking about why potentially they've decided that and I think you may see this echoing in other contexts in the government right now, why they want military to be doing things that they want to be done, and how they view the role of the military as a body within the government that executes the orders that they are given. And so those are the concerns that I have about that interaction between the duties that active military and service members have and what the job of a judge is.
Thank you both for sharing those overall discouraging updates, but also some hopeful thoughts. So we appreciate that. As we wrap up, we want to thank each of you for joining us today, for your commitment to due process and transparency in our immigration courts. Your presence and engagement are vital to shining a light on systems that often operate out of the public view. Our heartfelt thank you to Ilyce and Chloe for sharing their experiences and shedding light on the complex and evolving realities inside the immigration courtrooms. While we certainly couldn't get to every question, we hope that this conversation offered valuable insight and inspiration to you all. If you're interested in taking the next step, whether through training or court observation, we invite you to join our VOMO volunteer platform, and I've dropped the link in the chat to connect with our Witness for Justice team at our email, w4j@acaciajustice.org, with any questions. Together, we can continue building a more transparent and accountable immigration system. Thank you all so much, and thank you for all of your hard work, and take care.